Good evening, all, and welcome to part 2 of Live Well, Plan Well. This is the second part of our series of 2 seminars. Tonight we have with us lawyers from Mann again. We have Heather Austin Scarrett and Kate Wright. I'll introduce them a little bit later, but first I'll go through things and tell you who I am. My name is Anna Silverman, and I'm a licensed funeral pre-planning counselor with Hulse, Playfair McGarry. And it's an honor to be with you this evening. For those of you who don't know, November is Make a Will Month. Funeral prearrangements play a very important part in estate planning. I'm here to provide you with knowledge and information on the process of pre-planning, and Heather and Kate will provide guidance through the financial and legal process of making your estate plans well thought out. A couple of housekeeping items. As I mentioned earlier, it's a virtual seminar, so your mics will be turned off and your pictures will be turned off. And the evening program is being recorded and it will be available to everyone shortly after we're done. Due to the overwhelming response of the first seminar, we've provided a little bit of time for questions and answers at the end, and we'll do our best to get through as many as we can. We do have a few that were sent in that we'll deal with first, and then we'll see how our timing is to go through some more. And if there's something that we don't touch on that you really want to know about, please feel free to send us a message at info@hulseplayfairmcgarry.ca. We'd be delighted to assist you with anything. Without further ado, I'd like to introduce to you Heather Austin Scarrett. She's the co-managing partner and head of wills and estates and estate litigation at Mann Lawyers here in Ottawa, and her colleague Kate Wright, wills and estates, estate litigation, and head of family law. Welcome to you, Kate and Heather. Clara, can we get Kate and Heather in? Okay, we seem to be having a little bit of technical difficulty here.
We're here. We just can, Clara, if Clara can allow us to share our video, we can see our faces as well as hear our voices.
We can see your names up on the screen. Oh, there you are.
There we are.
Good evening, everybody.
All right, ladies, I will turn it over to you now for the next 15 or 20 minutes to share some knowledge with our folks.
Thank you, Anna. So I'm going to share my screen with everyone and want to welcome you to our Make a Will Month Estate Administration Edition. So tonight, Heather and I are going to touch on topics related to the administration of estates and talk about some of the things to be thinking of when you're doing the planning, but also if you're acting in the role of an estate trustee, we'll provide you with some information on what the role entails and some things to be aware of. So tonight we're going to go over duties of an estate trustee, estate administration, some income tax things to be thinking about on death, and potential litigation and hopefully how to avoid that litigation. So starting with an estate trustee. An estate trustee, you might also hear referred to as an executor. This is going to be the person you appoint in your will, or if you are in the unfortunate circumstances of having someone die in your family without having a will, someone can apply to be appointed as the executor. And this is a really, really big job. And I, want to always stress with my clients that acting in the role of an executor is very time consuming. It's a very important role. And so we really want to make sure that we're making the right choice in selecting our estate trustee. We don't want to leave it up to chance. We don't want to have, there being a scramble after someone has passed and the family members left behind are having to figure out who should be acting. So on this slide, you'll see a very general overview of what an estate trustee is going to do. So very broadly, their job is to figure out the assets and debts of the estate, to make funeral and burial arrangements in accordance, hopefully, with the wishes that are expressed in a will or with the pre-planning that's already been done. They're going to make a probate application if that's required, file income tax returns, deal with CRA, and then eventually do an accounting of the estate and make the distribution to beneficiaries. So that may entail specific gifts that they're going to hand out or divvying up the residue amongst the beneficiaries named in the will or in accordance with an intestacy. So who should you be thinking about? What are the types of things that you need to be thinking about when selecting someone to act as your estate trustee? Very first is basic. The person has to be at least 18 years of age and have the ability to manage property, the mental capacity to manage property. So I have clients ask all the time, well, can I appoint my son who's 18 or can I appoint, my son's only 15 now, but can I put a provision that I want them to act when they're a certain age? Generally speaking, we should be appointing people in these roles that would be ready to act when something happens, and we don't always know when that's going to be. Even though they can act at 18, whether or not an 18-year-old is the best choice to act as an estate trustee, I don't know many 18-year-olds who could take it on, but
Especially if they're grieving after having just lost a parent. It's a lot to put on someone's shoulders. It's a nice sign of respect and trust and that you have in your child, but it's a daunting job and it could take up to a year and a half to finish. So that's something to bear in mind.
yes. So while allowed, you might want to think about whether or not they're the most appropriate choice. So who is appropriate? We've listed, some of the things to think of when you're selecting an estate trustee. And as Heather just alluded to, it's a big job. It can be very time consuming, and it does, take a lot of diligence to make sure it's done properly. An estate trustee is going to have the ability to hire a lawyer to assist with a probate application, have an accountant to help with taxes. It's not like they're going to necessarily be left totally on their own, but they do have to make sure they're moving the file along, taking the steps that they need to, going out, getting all of the information about the assets, making sure they've done their due diligence and looking for a last will and making sure it is the last will. So you want to think of somebody who is going to have the time and the ability to carry this on. You also want to think about ages. So if you're thinking of appointing a sibling, are they of a similar age to you? Are they also, getting up there in age? Is this a job that they're going to be taking on, being able to take on in the foreseeable future? So I encourage clients to think about their will, a 5 to 10 year window, and how does that look in the next 5 years, 10 years? Is that person still going to be able to carry on that task? One other thing, and Heather might touch on this in a little bit more detail, is you want to think about where your estate trustee resides. So they should be a resident of Canada for sure, and there are income tax reasons to avoid that and to avoid the need for security when you make a probate application. A lot of clients will ask, well, can I ask my, cousin who lives in Vancouver to do it? And yes, and if they're the most appropriate person, if they're the best person for the job and there's nobody local, then absolutely. Between someone local and someone far away, having someone local does have it makes it easier on the person who's doing it to be in the location where, or at least closer to the location where the deceased resided. How many estate trustees should you have? So you certainly want to have one and a backup. You can have estate trustees acting jointly. So you can have two or more acting together. They must make decisions on consent of all of them. When we talk about POAs, we talk about them acting joint and several, which means they can act independently of each other. But for estate trustees, they must act jointly. And so if you're appointing two, do they get along? Are they going to be able to resolve disputes together? Because they have to have unanimous decision making. If you have three, you can have a mechanism in there to resolve disputes like a majority rules clause, but still you want to think about their relationship and their ability to work together to resolve any disputes that arise.
Kate, if you have multiple people appointed as a state trustee and one of them doesn't want to do the job, or you're the one who's appointed, you don't want to do the job, what can that person do?
So if a will appoints, let's say 3 people and one says, I don't want to do it, the other 2 can act. So one can renounce and the other 2 can carry on together jointly. And
yeah, unless there's a provision that says we always have to have 3.
Unless there's that, then you need to be careful. So the most common, people we look to act in this role is our family members. So a spouse, our children, if they're adult children, potentially siblings or parents. I get clients, and I'm sure Heather does too, that says, I have 3 kids, I'm appointing all 3 kids. I want to make sure, they know I love them all equally. I'm going to appoint them all together. And then you dig down further and you discover that, well, actually one is an accountant and would be really good in this role. And the other person, lives far away. It would make it more challenging for them to act. So you really need to think about who amongst your children or your family members are appropriate. Ensure there's no conflict.
And sometimes, the choice of family members and the skill set, although we love our family dearly, sometimes the skill set isn't quite what's needed. So then we have a conversation with clients to look outside the scope of family.
Yep. And there's lots of options for non-family members to act. So there are corporate executors. All of the big banks have trust companies. There are also smaller trust companies that exist. These are professional estate administrators. They bring to the role a lot of expertise, and they can also act along with family members. So if you want to appoint someone, but you're worried about their time, they have a busy life, you want them to make the decisions, they're capable, but they're very busy, you can appoint them with a trust company, and the trust company will really take on the burden of the day-to-day. You can also appoint professionals like lawyers, accountants. You want to make sure, if you're doing that and with trust companies as well, that compensation and how that is going to be paid is discussed in advance and should be clearly addressed.
I jumped a slide on you. Sorry, Kate.
That's okay. So yes, you can refuse to act, as we've said. So what happens if your primary estate trustee, for example, is deceased and your backup refuses to act or is unable to act? If there is no one under the will, then typically a beneficiary or another family member will step up to administer. And if all else fails, the public guardian and trustee will take on the administration. I think the threshold is 10,000 for them to take on the administration. So they are there as a last resort. And compensation. estate trustees are entitled to compensation. Estate trustee compensation is taxable. So you need to think about whether or not it makes sense to take compensation if you're also a residual beneficiary, because the gift that you receive under the will is not taxable. But generally speaking, the estate trustee, the rule of thumb is 5% of the gross value of the estate. And we've set out there sort of the technicalities of how we calculate that. But overall, 5% of the value. That amount can be adjusted upwards or downwards, depending on the size of the estate, the complexity of the estate, and any other factors that have made it more difficult or easier to administer. And we look at whether the amount of compensation really fits with the skill and the work that was required.
Great. All right, so I'm going to take over the last half of this presentation. And what we all knew as probate is now called an application for certificate of appointment of estate trustee with or without a will. So the most common question we get asked is, does this estate need to go to probate? And what is probate? So probate is simply an application that the executor makes to the court in the jurisdiction in which the deceased was ordinarily living when they died. It's an application process. It doesn't require an appearance unless there's an objection. It is tied to putting in the application with the original will, evidence that it was prepared appropriately, and with a lot of other draft documentation, the executor will get the certificate back. The forms have changed recently, and when the certificate is applied for, it is mailed out. The application is mailed out to all of the named beneficiaries in the will who are going to receive a portion of the residue. It's not a decision of the court who has to, whether probate is going to be applied for or not. It's usually a decision that's made because of the third party institution that's holding the asset that the executor needs to get to be able to administer the will. So the bank or the investment house or the insurance company. When someone dies, assets will either pass because of what the will says, or because of the nature of how the asset is owned or designated. So not all wills must be submitted to court to get the certificate before the executor can act. If all of the assets are of such a nature that the executor is able to call them in, realize them, and be able to distribute without having to get probate, then that's a possibility.
Do I need probate if I have a house?
Yes, we have a whole bunch of examples to go
Good.
through. So the amount of probate tax, the estate administration tax that is paid is dependent on the value of the estate passing under the will. So I've said there's new procedures, there's new forms. There's also a new style of estate. So the quote unquote small estate is supposed to be a more efficient process of administering an estate, getting the certificate without all of the additional materials that are necessary for a full-blown application. In our jurisdiction, in Ottawa, it usually takes about 4 to 6 weeks to get the certificate back. So when we look at how do we calculate probate tax? So the probate tax is chargeable on every $1,000 after the first $50,000 at the rate of 15%. So 1.5% of the estate after $50,000 based on the value of the assets that are passing under the will itself. So as Kate was asking, what assets would require and trigger that need for probate? So assets that are, let's start with the not. We have 2 egg baskets, one probatable assets, the other non-probatable assets. So true joint assets, assets that are held with the intention that they pass to the surviving joint owner do not require probate. Real property located outside of the province of Ontario, the value of that property is not included for the purposes of calculating probate tax. Assets that have a designated beneficiary, so you're thinking about your registered plans or your insurance policies, and shares in a privately held corporation, provided there is a secondary will in place. And that's a tricky concept that we're not going to cover in this seminar, hoping that Anna will invite us back to talk about that at another time.
So I have a question, Heather. If I own a joint bank account with my mother,
Yes,
the bank has said we can avoid probate.
yes.
So I won't have to pay probate tax on that, right?
No, not necessarily
Oh,
right. It's
darn.
never as easy as that. So there's a concept at law called a resulting trust. And so if the law is, from the Supreme Court of Canada decision, if an adult child holds a joint asset like a bank account or a piece of real property jointly with a parent, absent evidence to the contrary, it is deemed to be held on a resulting trust for the benefit of all of the beneficiaries of the estate. So if you have one child and you intend to leave all of your assets to that one child, then it would make a lot of sense to hold certain accounts jointly, but not necessarily to transfer that piece of real property into a joint account with that adult child. Why, you might ask? Income tax. What are the two certainties in life? Death and income taxes. So if you have a principal residence in your name alone, and your only child happens to own their own home too, and you add your child to the title of your principal residence to avoid probate tax, you will very likely avoid probate tax, but there will be a capital gain for that child when that house is disposed of, because it's a secondary residence for that child. So doing piecemeal planning to avoid probate taxes is a very dangerous thing. Probate tax is calculated at the rate of 1.5%. The inclusion rate for capital gains is 50% of the gain at your marginal rate. So what you might be doing is throwing out the baby with the bathwater to avoid something that was not going to cost that much to begin with.
And as the family lawyer in the group, I would also suggest you be cautious about adding your kids to any assets unless you want to get them commingled in a little marital dispute. I have one more question on this. I know we have to move on, but if someone signs at the bank and it says right of survivorship, that's enough evidence, right?
Not necessarily. We have two competing cases in Ontario dealing with this issue right now, and we've got two live files in our office about whether or not the designation and the joint account is going to pass to the intended beneficiary, or whether it was a probate avoidance technique. So you can either pay the 1.5%, you can plan accordingly, you can leave sufficient evidence like a deed of gift or a recital in the will that you intend that account to pass to the joint account holder who is your child, or you can litigate. And we really like to draft and plan to avoid litigation.
Be explicit, yes.
Go forward a couple slides. So the two certainties, the other one, income tax. So why is this all relevant? When you die, you are deemed to have disposed of all of your property at fair market value. That's what CRA thinks. So you look at ways of making sure that the estate plan you have is going to be sufficient to pay the tax liability on your death. And you look at things that will have the taxes otherwise deferred until a later time period. So as between spouses, wills and designations that leave assets to the survivor of the two spouses are generally going to be exempt from capital gains tax, because the surviving spouse typically will take at what's called the adjusted cost base for the spouse who has died. So if the cottage property was worth $100,000, oh, there's an example in here. Sorry, I should be following this example. These are not the updated slides on this one. So ignore the year on this particular slide. We are lawyers, we are not accountants. And I was concerned that there was a magic date in 94 that might have an impact on this. Let's move on from this one. Suffice to say that if there's a capital gain, the 50% of the gain is caught and taxed at the marginal rate of the deceased taxpayer. Exemptions are available for spouses and for certain types of assets. The principal residence has been for the longest while the major exemption from capital gains on death, and it is still that case. However, you now have to file with your annual return. If you've sold your principal residence, you have to file, I forget the name of the form, but there's a number on the form for the income tax to say that you've sold your principal residence. On death, it is still exempt, provided it truly is your principal residence. Spousal rollovers, you take it the cost base. So if you have shares in a company and there would otherwise be a capital gain, as long as the shares are being passed to your spouse, they'll pass at the adjusted cost base of the deceased spouse, no capital gains until the surviving spouse who inherits them sells them or that spouse dies. The lifetime capital gains exemption we're showing for 2021, but it's actually slightly higher. It goes up by a certain percentage every year, and the 2022 rate is higher. We're going to pass through this one because we're running out of time, and we're going to go to this one. So Kate was peppering me with questions about ownership issues. So real property held on joint account will pass by right of survivorship in the land registry office. If it's a principal residence, there is no capital gains. And in case that
Hello, pharmacist, can I help you?
timer.
Hi, Amanda.
Sorry, are we getting?
Okay, Margaret, what's the last name?
Oh, sorry, somebody was coming in. So that was another technical glitch. In this example, this person had assets in 2 different jurisdictions and registered assets. So the non-registered investment account, which does not have a designated beneficiary and is owned solely by the deceased, would force probate on death. Once one asset is caught for probate, then any assets owned by the deceased in their name alone, not on joint account, and not designated to a beneficiary would be caught and counted for probate tax purposes, and that's payable to the province.
I don't think.
Are we?
Clara, I'm not sure everyone is seeing our slides now.
I can't see your slides, ladies.
Yeah, just we just have to have host capabilities. So Clara's probably just muting a few people. Here we go.
Okay.
Yeah, I think
There we
when other people got admitted, we sort of lost control there for a minute. Let's advance the slide. Right, so assuming that you've got an estate, you're hopeful that the will is valid, there are issues that may arise that could lead to litigation. So the validity of the will may be challenged because of the suggestion that it wasn't properly created, there was undue duress, the testator didn't have capacity when it was made, the testator had a spouse, but they didn't leave their spouse sufficient assets on death, so that makes them subject to an equalization claim. There may have been an abuse of the power of attorney leading to a deficit in the estate of the assets that should have been there. If you have made it through the validity issue and you're ready to do a disbursement to the beneficiaries may not like the way the accounting was done. And so if there's going to be a challenge to the estate accounts, it's called a passing of accounts. And that requires a court application for a judge to determine whether or not the accounts as presented by the executor are appropriate or not. If you have failed to provide support to a dependent, the will can be challenged. And if your estate trustees are not doing their job in a proper fashion, you can bring an application to have them removed. And last but not least, the joint accounts with an adult child, that's the resulting trust argument. So you can see that there are many ways for an estate administration to go off kilter, and it goes full circle back to who do you want to be running your estate to make sure that as many of these challenges can be avoided as possible are avoided. That was the quick run through. A lot of these examples in the slides, I apologize, there should have been a different set of slides brought forward. So we'll make sure that we get those to Anna and Clara. And the material is general in nature. So maybe now we'll move on to the questions, Anna.
So before we go to the questions, I just want to make a few comments on what some of the things that you talked about. And the one thing that I really learned from your presentation was, I think it's more complicated. I think planning your estate is a little bit more complicated and in-depth than the average person realizes. And it's really important, from what you have said this evening, to seek professional advice when you are doing your estate planning. And, you know, especially if you're using a trustee, pre-planning in that situation, I think, is really key. And when I meet with someone to do their pre-planning who has appointed, you know, a trust company as their trustee, I always encourage them to also let the trustee know that someone in the family can deal with the funeral home for timing of the funeral and that, because the trustee, timing of anything for them is not relevant, but it is relevant to the family. So if the trustee knows ahead of time that the person wants one person in the family to be making the decision on timing, that's always a good thing. The other thing that I realize is the importance of pre-planning, because with everything else that you're having to deal with, pre-planning is a big thing. And I think there's a big misconception, and I'm going to repeat myself a little bit from our last session because we have a lot more people online this time. But I think one of the big misconceptions about pre-planning is that if you want to walk into a funeral home and sit down with a pre-planning counselor and plan out your funeral, that you have to pay for it. And that is clearly and truly not the truth. That is certainly an option, and by prepaying, what you're doing is securing your price, that you will never pay more. But certainly the most important thing is that you don't want your family to have to be worrying about, when they're dealing with the grief of your death, you know, what was my mother's maiden name, or where was my father born, or stuff like that. So pre-planning is really, really an integral part of the whole plan. And I think you ladies would agree wholeheartedly with me on that one.
Absolutely.
Yeah. And the other thing that I wanted to mention, and it was really kind of interesting, because where you talked about the younger child that's not yet 18, would it be, and then you kind of went into, you know, the co-executor thing. So if your son was reaching or was of legal age, or your daughter, and you really wanted to honor them by making them an executor, would it be okay if you then put someone older and more responsible as a co-executor with them?
Well, they still have to be 18 to act. And again, I still come back to the conversation that I have with clients, like, you know, you can always change your will. You can do a codicil if you really want to appoint them. I don't know what your practice is, but I like to encourage them to go with, the person who's going to be able to, we know is going to be able to act and take on that responsibility.
I think you have to look at the other part of the will planning as well. So if you've said you want monies held in trust until your children are 25, and you've now made your child who's 18 the trustee of their own trust, well, chances are they're going to spend that money before they reach the age of 25. So if they're not responsible enough to look after their own money, they're probably not responsible enough to take on the administration. And again, it goes back to the idea of they're probably in school, they're grieving. If they're involved, they've probably lost the second parent or both of them at the same time. I totally respect that it's an honor, but it is a burden as well. And so a parent has a really hard choice to work through that situation. There is no good time to be an executor, right? You're an executor because a tragedy or something sad has happened. And it's a question of how much responsibility do you want to put on this child? So
Right.
I think differently about it now that I'm getting closer to an older age than I was when I was closer to 18.
That's true. Everybody thinks it's so exciting to be an executor, but it is a whole lot of work for sure. The other thing that I wanted to mention and bring up before we get into the questions is, as you get older and as you retire, you tend to travel more. And one of the things you have to be concerned about, okay, I'm going to travel. What happens if I die while I'm traveling? What does my family have to do to get me back? And how does all that look? And we have a membership in a travel plan where you never have to worry about it. If you are traveling, if you're climbing Mount Everest and something happens to you, or you're in Florida sitting on a beach, we will make sure this plan ensures that you make one phone call, and we worry about everything from finding a funeral home, getting you there, getting all the paperwork done, and getting you home. We will even bring someone from your home down there to travel back with you. And so that's another thing that when you're doing your pre-planning, it's
a lot of peace of mind, really.
That totally is, because the paperwork involved in trying to deal with that when you have no framework for it as an individual is horrific. So having that service available to your clients is a fantastic benefit.
And it's a very minimal one-time fee to be a lifetime member. And so I recommend it to my clients because I think it's a really good thing. So it's one of the things you can talk about when you're talking about pre-planning with your pre-planning counselor. So let's head into the questions now, because I don't want to run out of time before we can get to them. This one is about capital gains, and I noticed you may have answered some of these questions as we were going through. So we'll just kind of pop in and see. So about capital gains, an example, a person domiciled in Ontario and has a cottage property in Quebec. Do they need to have a will in each property, in each province, for property assets, and reference each of the properties in the will? Do the beneficiaries of that property have to pay capital gains tax if it is an inherited residence?
It's a good question, especially given our location. So a lot of us and a lot of our clients have cottages on the other side of the river. So I can say that it is easy to have a will in each province, a limited will in Quebec prepared by a notary, so that the property in Quebec can be transferred without waiting for the administration to be complete on the Ontario side. That being said, an Ontario will can be used to probate and pass property to beneficiaries on the Quebec side. Quebec does not have joint tenancy as a concept, so there's no right of survivorship with respect to real property on the Quebec side, which is very different than the Ontario side. So the second part of that question deals with capital gains, not to be confused with the estate administration tax. So if you're probating in Ontario, the value of the Quebec cottage is not caught for estate administration tax calculation purposes. But as I said, on date of death, you are going to be deemed to have disposed of all of your property at fair market value. And so if there is capital gains on the cottage, then yes, the estate will pay capital gains. Once the capital gains have been paid, then the property can be transferred to the beneficiaries named in the will, free of tax.
Ah,
The beneficiaries in Canada do not pay tax on inheritance. The estate pays tax, and what's left over passes to the beneficiaries. The problem we sometimes find with cottages is that there are insufficient cash assets in the estate to cover the capital gains tax on the cottage. And so that must be planned for.
oh, okay. That, again, hence the meeting with a professional to do your estate planning.
Exactly.
Yeah, next question. Do POAs made in Ontario still work in other provinces? So if the person has assets in another province that need to be dealt with, can the POA that was assigned in one province deal in another province?
Do you want to tackle that or do you want me to?
Go for it.
So it depends. It's a very lawyerly answer. So in Ontario, our Substitute Decisions Act has a provision, I think it's section 85, that says if a power of attorney is validly made in another province where the grantor of that power was living at the time it was made and it complies with the legislation in that province, Ontario will recognize it. That being said, each province has its own legislation. Nova Scotia just recently passed legislation that is similar to Ontario's legislation, which made me very happy since I'm a maritimer. That being said, the institution that you're dealing with may not like or recognize the power of attorney, notwithstanding that it's valid. Some institutions, some financial institutions, they don't even like the general powers of attorney that are prepared by lawyers in Ontario, let alone another province. So if you are intending to rely on it, you should check with the institution just to make sure they're not going to have an issue with it.
Okay, great. Thank you. Can you explain and talk about the meaning of the 30-day survivorship rule for an executor? And maybe give an example if someone dies before the 30 days and someone dies after, what is the difference?
So the 30-day survivorship rule is really to delay the period of time before like a gift can pass to or can vest in a beneficiary. So for example, if you have one spouse, they die day one, and then the will says, you know, everything to my spouse, they survived me by 30 days. Spouse number 2 dies on day 35. The residue will have already passed to that spouse, and then their will designate how all of that is going to be passed on. If they died on day 25, then we would look to the beneficiaries that come after that.
In will 1.
In will 1, yes, in the death in the first spouse to die. So it's really just to give a period of time before those gifts are going to be confirmed, who the beneficiaries are going to be. Now, if you have spouses that die within that 30-day period of each other, so as I just said, spouse 1 on day 1 and spouse 2 on day 25, and they have mirror wills. You want to be careful in the drafting of your wills that there's going to be language to ensure if there are specific gifts there that are intended to only be made once.
Like a cash gift of $10,000 to a charity.
Yep. That there's language to make sure that if they die within the 30 days of each other, it only goes from one spouse's estate.
Oh,
You don't double up.
interesting.
Double
legacy.
gift. Yeah.
So on that note, I have a question. So if the spouses made their wills, if I die first, it all goes to you, and if you die first, it all goes to you. when should that surviving spouse change their will?
Oh, that's a good question.
Mhm.
So first, you need to make sure that the wills were not intended to be contractual wills, so that the surviving spouse is not entitled to change their will after the first spouse dies.
So it's called mutual wills. You'll hear it referred to.
Yep. And if they are not mutual wills and they're merely mirror images of each other, then if they're well drafted in the first place, there's not an immediate need because the what ifs have been covered off.
Gotcha.
Sometimes it's a matter of just sitting down and making sure the surviving spouse understands what's in the will and how things are going to flow after having received certain assets by right of survivorship outside of the will.
Now, oftentimes, if the wills were prepared a long time ago, you want to think about who the backup was that you appointed, the backup estate trustee, that is. Who did you appoint, 15 years ago when you made your wills? That often more than the gifting provisions
Codicil to change
are the
executor
things. Yeah.
and the powers of attorney.
Yeah.
Because if you have your spouse appointed as the first person to be the attorney, if you need an attorney, and the child is the backup, then anytime they present that power of attorney to a bank, the bank's going to be wondering, why isn't the first choice doing this job? So you're always carrying around the death certificate.
Right.
So generally speaking, one of the first things the surviving spouse will do is update their powers of attorney while they're processing everything.
Okay.
Actually, Anna, one of the questions that has come up in the chat that
Okay.
is really very much on point is probate required on a holograph will?
Oh, I saw that. Yes.
Yeah, so let's just revisit what a holograph will is. So a holograph will is a testamentary document that clearly has the intent to dispose of the deceased person's assets. It is wholly in the deceased person's own handwriting, dated and signed at the bottom. In most cases, if there are significant assets at a financial institution, that holograph will have to go through the probate process before the institution will release the assets. Part of that is to try to establish that it in fact is the last will of the deceased person. So you have to go to extra steps to be able to establish the handwriting. So you have to submit affidavit evidence to say, I'm aware of, this looks like. Sometimes you have to go beyond the application process and prove in solemn form in court to prove that this is the last will. We certainly saw through the pandemic that a lot of people were trying to use holograph wills because they just couldn't get in to see lawyers and draft a formal will. Some people try to improve the quality of a holograph will by having it witnessed. That is not a good idea. It takes it outside of the case law regarding holograph wills and turns it into a will that is subject to the estate legislation. Yeah, I think that's all I wanted to say about that. It's possible. We've probated a number of holograph wills. I've probated one on a napkin. I've probated one that was written on the little notepads that come from charities after you make donations. Not the best way to go.
Okay. Have another question for you. What is the difference in powers between a joint POA, personal care and property, and one where there is one primary POA and a secondary?
Sure. So when you name a joint power of attorney, whether it's for care or for property, it is a joint appointment, much like executor. So the 2 or 3 people, whoever you've appointed jointly, must always act together. They cannot act individually. It has to be the collective. If you have a hierarchy, so you have person A appointed, and if they can't, person B, and if they can't, person C, then it is an order that must be followed. So if A is unable or unwilling to act and B steps up to act, A never comes back in the picture. So it is truly a hierarchy, kind of like Queen Elizabeth passing on the torch to now King Charles. So the follow-up to that question was, what about the sharing of information between those people? So
Right.
if you are all joint, then yes, the information has to be shared because the decision-making has to be shared amongst that collective. When you're a hierarchy, it's a challenge because the rights of privacy of the grantor of that power of attorney must be respected. And so when you are alone in that role, you're not necessarily sharing the details with any of the other powers of attorney because they've not taken up that office, if you will. And so the way I explain it to clients is, and when they get asked questions of family members who are not named in any power of attorney, they want to know, how much money does mom have? Or what's mom's health right now? You can make general comments about it, but I say, look, if you're at Sunday dinner or Saturday dinner and your sister asked your mother point blank, Mom, how much do you have in the investment portfolio? Would your mother answer her? Probably not. So it's surprising sometimes to me the questions that family members will put to the people who are acting as attorney that they would never put to the grantor of that power.
Yeah.
And it's a hard line to walk.
Yeah, that's interesting. Because they would think that they should know in case they actually had to take over.
Yes, and they don't need to know until they take over.
Okay, great. What is the difference between Healthcare Consent Act and the Consent to Treatment Act?
So the Consent to Treatment Act was actually repealed in 1996, I think. So that piece of legislation is no longer valid. The Healthcare Consent Act really is an act about, treatment, who can make treatment decisions for someone, to ensure that individuals have autonomy in their healthcare decisions, and to provide some protections for them. So what we talk about clients most often with respect to the Healthcare Consent Act is the hierarchy that it provides. And it sort of fills a vacuum if somebody, either does not have a power of attorney, or it very clearly sets out who's entitled to make decisions about treatment specifically. So and treatment is defined in the act, but really it's about health care decisions, not where, mom or dad live, not going to the retirement home, not anything outside of a healthcare facility. And it sets out, guardians are the first guardian of the person is the first person who has the authority to make decisions. There's no court-appointed guardian, no powers of attorney, and it goes on from there through the list of family members who can make decisions. So that's really that, in a very brief summary, that's really the role of that piece of legislation.
Okay, I think we answered this question earlier, but I'll let you ladies jump in. I'm sure it's a quick answer. What if your daughter lives outside of Canada? Should she be a power of attorney?
This quick answer is no. So most commonly we find clients who have family members in the US, and they would like to have them appointed as either the executor or a power of attorney for property decision making. So there are reporting obligations on a US citizen if they are named as an attorney, regardless of whether they're acting. The financial advisor for the client in Canada may not be licensed to take instructions from somebody outside of the jurisdiction. And on the estate side of things, the estate is really a trust, and the taxation of a trust is determined by where the controlling mind resides. And so if your controlling mind resides in the US, you might otherwise have now made a Canadian estate subject to all of the US tax laws. Not a good situation.
So what if you were to appoint, say, a trust company as your executor? Would it be not prudent to have your daughter as the co-executor?
In that case, we would often have the daughter who resides in the US as an advisor. So they're consulting with the trust company, but the trust company is responsible for the filings and the administration.
Okay, gotcha,
That gets
understand.
us around that.
Okay. Heather, do you see a question up there that you might want to answer quickly? We might have time for a couple of quick ones.
Yeah, let's have a look here. This is the role of the Office of the Children's Lawyer. So this relates to if you have trust for minors in the will and you are taking the will to probate, then you have to serve the Office of the Children's Lawyer with the application itself. And it's a funny named institution. It's a government office. They don't actually do anything for the administration of the estate, but they're there to oversee that minors' interests are being dealt with properly.
You have time for one more?
Yep.
Let's see.
Kate's scrolling. She's got better eyesight than I do.
Some of these we have covered.
Yeah. There's executor is just the old language for estate trustee. You can have an estate trustee of your will, and then if you have a trust for minor children, you can appoint a trustee of that children's trust who is different than the actual estate trustee who's administering the will. So when Kate talked about choice of age and how long somebody might be able to fulfill that role, when you've got a long-term trust for a minor, you can appoint somebody other than the executor who's looking after the estate.
So one of the questions, how do you plan tax money for capital gains? Question mark, life insurance. So yeah, life insurance is one way to address capital gains. It's not always an option depending on age and cost.
It's a tool, so it has to be looked at in the whole of the package. So working with the advisor and the accountant, we can get an idea of what the tax liability might look like and how it can be satisfied. We'll just below it as well. After death, if the application is being made to probate a will, then yes, every beneficiary who is named in the will is going to get a copy of it.
But the beneficiaries who are only given a specific bequest, like if you say, I'm going to give my niece $10,000 and my nephew, he gets 10,000, they only get the portion of the will that shows their gift, and they don't get any of the accounting. The residual beneficiaries, so the ones that are sharing everything else that's left over after the gifts and the taxes, they will get the whole will. They will see how many shares all of those beneficiaries get, and they see the accounting for everyone.
That being said, once you file it with court, it's a public document.
Yeah.
So if somebody was really interested, they could go and get a copy of it. So we sometimes have that discussion. Do we only send the page that has your gift, or do we send the whole will? Sometimes sending just the paragraph that has the gift provokes a little, and they could see it anyway. So yeah. Precatory memorandum. There's a question. So again, it's back to will drafting.
Yeah.
So somebody's asked very specifically, what is a precatory memorandum and what would you put in one? So a precatory memorandum is a written set of instructions from the testator dealing with the disbursement of personal effects. So if you would like to give your jewelry to someone or your art to someone, then you write up a memorandum. The reference to precatory means that it is not binding. It is an expression of your wishes, and it would only be morally binding on the executor to carry out those terms. If it were a binding memorandum, it would have to be in existence, signed by you, as at the date you sign your will, so that it becomes incorporated by reference, and we often include a copy of it with the will. When you're doing,
if you want to make changes to it,
then you have to update your will to make a change to it. When you are applying for probate and you are trying to come up with the estate administration tax value, personal effects need to be valued. And if you're the executor, chances are you're going to want appraisals done. Not appraisals for insurance purposes, but appraisals for resale value. So whether that's an auction house or some other type of company that provides that service, you're going to want a report, because as the executor, you are liable to be audited on the estate to see whether or not you've remitted the right amount of estate administration tax. And having backup documentation is of great assistance. When you have a memorandum, it has to be submitted with the application. So the court gets to see that as well. And after you get your certificate of appointment back, within 90 days, I believe, the executor must also file something called an estate information return that deals with a summary of all of the assets on a class by class basis and the value associated with each one. So the good folks at the province can do the audit and check and make sure the right amount of tax has been calculated, submitted, collected.
So here's a question clients will often ask, or estate trustees will ask. They'll say, well, they didn't give the personal effects to anyone specific in the will. They just said we could, divvy it up amongst ourselves and all that. So we don't have to value those for probate, right? Wrong. So even though they don't say my ring to my niece or my, watch to so-and-so, they're still personal effects. They still need to be valued for the purposes of a probate application if you're having to make that probate application.
That's really interesting. I never thought of like personal items like that as being part of that. So that's an eye opener for sure. I think we're running out of time here, and I want to take the opportunity to thank the both of you so much for both our sessions this month. It was great. I'm getting a sense that there's so much more to talk about in this area that we might have to do this again. I think it was great and really informative, and some of the questions that were coming through were pretty amazing questions as well. Again, the session is recorded, so if you missed something on it, you can rewatch it. I would ask those watching, because we want to be able to do more of these seminars, and we want to know what kind of information you're looking for. So if people watching can help us bring you the best content that you're looking for, if you can send us a quick note at info@hulseplayfairmcgarry.ca, that would be great, because it would just help us provide you with the kinds of seminars you'd like to see. And again, thank you all for joining us this evening. I hope you walked away with some useful information. And again, thank you to Heather and Kate. And I hope to see you girls again sometime. Have a good evening, everybody, and watch for our next seminars to come out.
Thanks for having us.
Thank you, Anna. It's been a pleasure.
Okay, thank you.
Thanks.